Good morning, everyone. My name is Zach Pyzik. I'm PRLA's Senior Director of Public Affairs, and I'm joined today by Lauren Brinjack. Lauren, would you like to say hello?
Hey everyone, thank you so much for being here. Lauren Brinjack, Senior Director of Legislative Affairs for PRLA. I'd like to welcome representatives from the PA Department of Labor and Industry on this webinar. We have with us James Holtzman, Strategic Initiative Specialist. And I believe also joining us shortly will be Brian Smolik, Labor Compliance Director. Thanks so much for being here, James. And I know that we all look forward to your presentation. So without further ado, I'm going to turn it over to you.
Good morning, everyone. Thank you all for joining us today. I know how busy your schedules are, and it's deeply appreciated that you could join us. I may talk fast because I think it's more important to try to answer your questions than to just strictly listen to my narrative. But we hope that this is helpful for you and helps you comply with our laws. We're going to discuss today the Wage Payment Collection Law and Pennsylvania's Minimum Wage Act. Pennsylvania's these are the two general wage laws in Pennsylvania. The difference may be the Wage Payment and Collection Law is what the employers promise, and the Minimum Wage Act is what they have to do. As you also may be aware, there's a federal Fair Labor Standards Act that governs wages, but under federal law and state law, Pennsylvania can impose more higher requirements. Okay, so there's a definition of wages under Pennsylvania's Wage Payment Collection Law. This is still on your screen, correct? Yeah, I think it is. Okay. These are all employee earnings, anything calculated based upon time, piece, commission, fringe benefits, and wage supplements. Future wages are not wages. Discretionary bonuses and payments owed to independent contractors are not wages. Employers have to pay wages on the regularly scheduled payday. You can change the pay rates, but you have to provide notice. They're payable in cash or bank check, and the employee approves by direct deposit. And as I said earlier, when you hire employees, you have to notify them of these pay schedules and rates. And employees, and this is also true under the Minimum Wage Act, cannot waive their rights by making an agreement. These are the time periods when wages are due. Basically, the end of the pay period. Overtime pay can be paid in the next pay period. And separated employers are entitled to wages on their next regular payday, where they would have normally been paid. Employers are allowed to take deductions from pay. The general rule is that it has to be authorized in writing by the employee and for the employee's convenience. And there's a list of authorized deductions under the PA code, which is on our website. Basically, unauthorized deductions are employment work rule violations, damaged property, or failure to provide sufficient notice of quitting. There are some things exempt from the Wage Payment Collection Law. Federal ERISA recognized benefits are recognized if business declare bankruptcy, it may preempt the payment of wages. The Wage Payment and Collection Law and the Minimum Wage Act only cover private employers, not state or local governments. cannot initiate a legal action for anything covered by a collective bargaining agreement. It does not cover independent contractors or what you call 1099 employees, and they have to meet certain requirements. And it doesn't cover corporations, but it does cover corporate employees who can exercise their rights under this law. Employees have various duties under that law. They must give written notice to employee for any amount that is conceded is due and pay that amount even if there's a dispute. You must provide records to the Bureau for Bureau inspection. If they're kept out of the state, they must be sent to the state within 7 days. If it's in a certain format, you have to provide equipment so we can review them. And employers have to allow the Bureau to interrogate any employee during business hours. There's private and government legal actions can be taken under the wage payment and collection law. Employees on their own can file an action, typically before district justice, unless it exceeds, I believe, $12,000. They can seek liquidated damages. They can also assign their claim to the Bureau of Labor Law Compliance, who can take over the action, and we can investigate it, review employees. We typically notify the employer of claim by mail, and employers must file a good faith response in 10 days. If they don't, when we file legal action, we can tack on another 10% penalty for not sending a good faith complaint. And claims have to be filed with the court within 3 years from the date the wages were due. The Bureau also has the authority to file criminal actions under the wage payment collection law. There's summary offenses, and we can hold corporate, or the court can hold corporate officials liable. And some of the examples of violations is failure to pay employees on time without notice, failure to pay employees their last paycheck when they quit, failure to comply with agreements to pay employees, failure to provide access to our investigators, and taking improper wage deductions. And now we'll go to the Minimum Wage Act, which I think you'll probably have the most questions on. Establishes a fixed minimum wage and overtime rate for employees in Pennsylvania. The Pennsylvania minimum wage rate is based on the federal prevailing wage rate if it's higher, and that's currently $7.25 an hour. Overtime is 1.5 times their regular rate of pay after 40 hours worked in a week. It's based on a 40-hour work week. And as I said earlier, we can provide more protections than the Federal Fair Labor Standards Act. And there are some minimum wage rate and overtime exclusions under the Pennsylvania Minimum Wage Act. I really don't think they're applicable to the restaurant or hospitality industry, possibly if it's a seasonal business. And there's exemptions from overtime rates strictly. The Minimum Wage Act provides for allowances. These may include reasonable and actual cost of board, lodging, and other facilities. These have to, notice has to be provided to the employees upon hiring or classification change. And as you probably know, the wages, including the food credit plus tips, must equal the current minimum wage. So the 283 requirement plus the tip must equal $7.25 an hour. Requires pay for all hours worked, and that's time that the employer requires an employee to be on its premises. Even if they're not doing their typical job, if the employer makes them come in at a certain time or participate in a workplace meeting or put on special clothing, they have to be paid for that time. And of course, anytime that they're working. Unlike federal law, there's no de minimis time exemption under our minimum wage act. There's a state Supreme Court case from, I believe, 2 or 3 years ago, where Amazon required security clearances if anyone was bringing up a knapsack or a purse on the premises. It took roughly 8.5 minutes to get through security clearing, and the Supreme Court ruled that they had to be paid for that time. You do not have to pay employees for time spent at the workplace if they don't have to be there. If it's for their convenience. Time allowed for meals, unless you unless they're working during that time. That's typical, someone eating lunch and doing work at their desk. I guess in the restaurant industry, back in the day, I'd get lunch, put it at the end of the bar, be bartending, grabbing a bite of the sandwich. I was entitled to pay for that time. Rest or meal periods that are usually 20 minutes or less should be compensated as work time. Travel time is compensated depending on what's going on. Home to the workplace is not compensated. If they have to report to work and they're sent somewhere else, the time traveling to somewhere else does require compensation. Home to work on a special one-day assignment in other cities compensated. Travel away from home communities compensated if it's during the workday. And work from, if they go from the workplace to place A, then from place A to place B, all that time is compensated. And if they do any work while traveling, that's compensated. So if they're passenger in a car and they're working on their laptop, they get compensated for that time. Tipped employees, our regulations were updated on August 5th of 2022. Employers may take a tip credit for the employee's base hourly rate if the employee earns at least $135 in tips per month. As I said earlier, their base hourly rate plus tips must equal $7.25 per hour, or the employer has to make the difference up. All tips and gratuities paid by credit card or other non-cash payment methods, which is becoming the norm these days, are the employee's property. Employers may not deduct credit card or other processing fees from employees' tips. Tip polling's allowed for employees who are paid a tip credit at minimum wage. May include individuals and occupations who customarily and regularly receive tips. Managers, supervisors, and employers may not receive tips from a tip poll. even if they're serving customers, but they may elect to contribute any earned tips into that pool. The one exception is if they do a complete service for a customer and a customer hands them the tip, they can keep that tip. Service fees, providers of banquets, special functions, or package deals must provide patrons with contracts or bill as separate lines for automatic administrative or service fees that cover operational costs and for gratuities or tips intended by the patron to be paid to the employee who provided the service. And while we're on the subject of tips, there was a question presented by your organization, I believe at the end of August, on whether servers can provide bartenders with tips. And my understanding from my experience is at the end of the shift, servers provide tips it's typically of a certain percentage to the bartender, because the bartender was mixing their drinks, and that is allowable. I would recommend that you inform servers when you hire them of that requirement. Employers cannot take a tip credit for an employee if they spend over 20% of their weekly hours on duties that do not directly generate tips, which include taking orders, serving food and drinks, preparing alcoholic beverages, bussing tables during meal service, making recommendations, and processing payments. Items that do not directly generate tips are side things like painting, taking inventory of backroom supplies, ordering supplies, scheduling and cleaning bathrooms. Home healthcare workers are covered by the Minimum Wage Act and entitled to overtime. I don't believe on-call time is part of your industry. That's basically where employees are on standby. They're typically away from the place of business, but they agree to return to work. Payment depends on how much of their on free time is restricted, and we take a look on those on a case-by-case basis. Overtime is 1.5 times regular rate of pay for any time over a 40-hour work week. Salaried employees are eligible for overtime if they do not perform administrative or professional duties and make less than $684 per week, or $35,568 per year. Through various reasons, our regulations on executive, administrative, or professional exemption were struck down by the legislature. So employees should follow the Fair Labor Standard Act requirements. There's special rules for certain hospitals on overtime. Employers cannot waive their right to receive overtime. Employers cannot provide compensatory time instead of overtime pay. Number of employees an employer has does not affect overtime. Employers are also required to provide a pay stub or a pay statement with every pay date containing hours worked, rates paid, gross wages, allowances, deductions, and net wages. Employers also, like the wage payment collection law, have a record keeping requirements. Records must contain all your employees' names, their occupation, hours worked in that occupation, daily and weekly hours worked, total work week wages, including overtime, allowances, total wages paid for each pay period, payment dates and pay period covered, total deductions. And again, you should keep these records for 3 years. Employers must place our Labor and Industry Minimum Wage Act poster in a conspicuous place. We also have a Child Labor Act poster that must be placed. Employers have to provide access to records to our investigators, interrogate employees during working hours, and provide wage summaries to us if requested. Like the wage payment collection law, employees or the Bureau of Labor Law Compliance can file a legal action. It's typically before district justice. The Bureau can file it if it receives a wage assignment. Employers can be held liable for cost and legal fees. Again, any agreement to pay lower wages is not a defense, and there's a 3-year statute of limitations. There's also a possibility of criminal summary charge for underpayment and other violations of the Minimum Wage Act. Some of the violations we found over the years were inaccurate wage records or no wage records, taking retaliation against an employee who testifies in a Minimum Wage Act proceeding, overtime, failure to pay overtime, deducting credit card or other processing fees from employees' tips or taking tips from their tip pool, and failure to provide records to our department. And we have 5 regional offices throughout the state. Basically, they're each assigned a geographical area, and they assist complainants, or they can also assist you if you have any questions. We also have a website of all our labor standards laws, including minimum wage, wage payment collection law, and Child Labor Act. It has the posters, it has forms, complaint forms for employees. And if you, I also placed the U.S. Department of Labor website on that page. So that's briefly Pennsylvania's Minimum Wage Act and wage payment and collection law. I leave it to you all. Do you want to go to the Child Labor Act, or do you have any questions at this time?
Hey, Jim, this is Zach. Just wanted to jump in. Thank you for covering that. And I see, good morning, Brian. I see Brian has joined us for the conversation as well. Thank you, Brian, for joining us. And perhaps we'll still have time for questions at the end. Before we do move on to the Child Labor Act, I was wondering, Jim, I know you scraped the surface on this, but would you guys mind expanding a little more on what is and isn't allowable as it relates to tip outs? I know, how that meshes with tip pooling, how you guys govern those rules and regulations that are related to that subject. As you pointed out, Jim, tipping out and tip outs in general are pretty common in the industry. And I know it's one of the most commonly asked questions that we receive that we oftentimes send your way. And so I was wondering if you guys might be able to expand on some of the common FAQs on that subject a little bit.
The examples I'm aware of, and this is from many years ago when I was bartending, was, of course, at the end of the shift, whether it was a service bar or restaurant bar, that the servers pay the bartender a certain percentage of their tips at the end of the shift. I also believe there were probably circumstances that the servers and the bartenders pay what was called the bar backs and the busboys a certain percentage um, for their assistance, and that's legal. Brian, do you have any other examples that have come up on your end?
Yeah, I can speak a bit. Can you all hear me, by the way? Zach, am I audible? Jim, audible? Good.
I can hear you, Brian.
Um,
Thank
Okay, very good. So I can speak to this sort of broadly. Clearly, I'm not going to mention certain business names or even locations, but we have seen an increase in questions and complaints since the new tip regulations went into effect, which makes sense, right? Obviously, you change something and you begin to, you know, start dialing up some of those types of complaints. What we have seen so far have been, on one hand, some egregious, on the other hand, some completely accidental. The egregious nature being more along the lines of there's a tip jar on a counter and people actively put tips in there and no workers ever get the tips, went all to the employer. That was a problem, right? So when we address those types of complaints, we have to audit. Becomes very tedious auditing how much money in tips people left because it's a gratuity, right? So is there a credit card receipt? Is there evidence of what was in that tip jar that day? Now, I think what we also see is more along the lines of these, unintentional violations that occur many times with perhaps the tip pool that has someone in there that maybe shouldn't be. And it may have been a facility just trying to be nicer to someone. And it turns out to be a problem because the tip regulations are very clear when it comes to front of the house versus back of the house when a certain front of the house is making less than the 7.25 an hour. What Jim has mentioned as well is completely permissible. To have a tip sharing amongst different employees is fine. It just comes down to who's in that tip pool. And we've stressed since last year's presentations to ensure that a tip pool does not feature non-tipped workers when you have this group of tipped workers who make less than 7.25. That's the biggest issues that we've seen with mistakes as we educate different businesses. I hope that kind of answers the question, but there's a lot of scenarios out there, so it's tough to have a one-size-fits-all answer.
Okay. And if you think of, and I throw this out, if anyone thinks of a wage question at any time during the Child Labor Act or after the Child Labor Act, please ask us. So no questions are precluded. We'll go through the Pennsylvania's Child Labor Act. Some of the slides we'll go through quickly because it really does not pertain to the hospitality industry. But if there's something that someone's interested in, I'll be glad to go back. And this is what we're going to go through this morning. Some of the things are not really applicable. History of the law, Pennsylvania was basically one of the first states to have a Child Labor Act. From when I was still at the Bureau in an earlier job, we were still using the law that was passed in 1915 that was amended in 1935. Fortunately, in 2013, we passed a new law to cover changes that obviously took place. The old law was a Model T law in a virtual world or whatever metaphor that you wanted to choose. Our new law took effect on January 22nd, 2013. The Labor Act covers a lot of things. Child Labor Act, age restrictions, work permits, employers' duties, work hour limitations, prohibited occupations, some of the exceptions for sport attendance services, children and entertainment, volunteer emergency service, and we'll also go through enforcement violations and penalties. Some of the biggest issues we see in restaurants and hospitality are minors not getting work permits, record violations, and hour violations and break violations, and we'll cover those. These are some of the exclusions from our law. Um, just babysitting and the minor mowing lawns for the neighbor is not covered. The general rules, minor has to be at least 14. There's some exceptions for newspapers, delivery or workers. All minors under 18 must have a wallet-sized transferable work permit issued by an issuing officer. That's typically somebody at the minor's school district where they live. Issuing officers can refuse to issue or revoke a work permit because of inadequate academic achievement. Issuing officers are supposed to cooperate with us and other law enforcement agencies on Child Labor Act compliance. Briefly, the minor has to submit proof of age, appear for inspection before the school district official, and entertainment permits for television, movies, virtual presentations, other performances are not issued by the school districts, but our department directly. Employers have duties from the get-go. If the minor is under 16, they have to obtain a written verification from the minor's parent or legal guardian, acknowledging their understanding of the minor's duty in employment hours and granting permission for the minor to work. And we have that form on our website. These duties are missed a lot. For any minor under 18, the employer must, within 5 days of beginning of employment, submit written notification containing the normal work duties and hours, the minor's age, and the permit number, the work permit number, to the school district official. And within 5 days after the minor's end of employment, they must provide notice to the school district that they're no longer employed. These are transferable work permits, so they can be used from employer to employer. They changed from the days where the minor first had to get a job and they had a work permit that just applied to that job. Now the work permit is transferable to employer, but employers must provide that 5 days notice of commencement of work and when the employee is ends their employment. Like the Minimum Wage Act and Wage Payment Collection Law, there's various record keeping requirements that employers must have. You have to keep a copy of the minor's work permit, the permission statement for minors under 16, and that 5-day letter, list of all minors employed at the workplace, schedule for all minors, containing the maximum hours of work, their weekly total, the daily hours for commencing and stopping work, and the time allowed for meals. You also have to keep those Minimum Wage Act hours records we discussed. And you have to provide access to the Bureau and other enforcement officers, such as school district officials and police or district attorneys. These rules apply to all minors under 18. They may not work for more than 5 continuous hours without a 30-minute break. They can't work for more than 6 consecutive days. For work week schedules during school time, we're talking about a Monday through Friday when school's in session. And if there's entertainment permits, that's governed by different rules enforced by our department. 16 and 17-year-olds have more liberal hours or more flexible hours than a 14 or 15-year-old. During school, and that includes summer school, their hours have to be between 6 a.m. and 12 a.m., 8 hours maximum per day, and 28-hour maximum during regular school week. During vacations, they can be employed until 1 a.m., 10 hours max per day. You can go up to 48 hours, but minors can object to hours exceeding 44 hours. So you can compel them to work 44 hours. And they are allowed, if they want to work 48 up to 48 hours, but they can object to working between the 44 and 48 hours. School vacation includes Saturdays and Sundays. If a vacation day precedes a Saturday or follows a Sunday, there are special rules for camp counselors, sports attendants. If you have a minor who graduated high school before they reached 18, if they're 17, they're a high school graduate, or they got authorization from school not to attend, the work hour rules do not apply, but they still need, they're still entitled to breaks, and you still need a work permit for them. 14 and 15-year-olds have more restrictive hours, which I have here, between 7 a.m. and 7 p.m. during school days. 3 hours max on a school day, 8-hour maximum on Saturday and Sunday. 18 hours during the regular Monday through Friday school week. School vacation, they're allowed to work 7 a.m. and 9 p.m. 8-hour maximum, 40 hours maximum per week. There's some exceptions which would not apply to you. Okay, there are occupations that are prohibited by the federal government under the Fair Labor Standards Act. In our department, under the Child Labor Act or our regulations, and anything that violates the prohibited occupation rules under the Fair Labor Standard Act automatically violates the Child Labor Act. The big one in your business would be at establishments serving alcohol. They cannot do that, but there are exceptions. A minor who's at least 16 may work in part of the establishment where alcohol is not served. A minor who's at least 16 may serve food and clear tables in hotel, club, or restaurant that has a PLCB Sunday liquor license, but minors cannot dispense or serve alcoholic beverages. They have to be at least 18. A minor under 16 may work at a ski resort, bowling alley, golf course, amusement park, or recreational establishment if they're not working in an area where alcohol is located or served. Students receiving instruction or performing art to perform an exhibition of the student is not compensated and is under proper supervision. That's basically the situation on St. Patrick's Day, where minors and a dance group come in, do a dance, they have adults with them, and then they leave. That's allowed. There's various prohibited occupations, which I doubt apply to your business. There's an exception in the law for sport attendance services. That's basically what they used to call ball boys and girls, bat boys and girls. Entertainment permits, which I discussed earlier, those are issued by Labor and Industry. That's for performances. I guess that would apply to your industry if you had a minor who was singing or doing some sort of presentation, but they're limited from working in facilities that serve alcohol. Minors can, under certain circumstances, serve in emergency service organizations. They still need work permits. That's mostly for training permit purposes. They can provide assistance in at emergencies, but basically it's like serving food, rendering first aid away from the emergency area. They cannot put out fires or rescue people from trapped in cars and things like that. Our Bureau enforces the Child Labor Act. The new law provided us with a lot of powers. We can issue investigative subpoenas for records. We can enter and inspect any establishment at reasonable times to ascertain working conditions. We can interview workers. We can inspect and obtain copies of records. And we can prosecute alleged violations. Other government individuals who have these powers are the chief school administrator, the attendance officer, the issuing officer, and any law enforcement agencies. One of the powers that enforcement officers like us have under the law is that we can require employers to provide proof of an employee's age within 10 days, or demand that they terminate the minor for being underage within 10 days. And if an employer does not do that, that is a violation of the Child Labor Act. Violations are violating any provision of the act. So that's, you have a minor working without work permits or around liquor without the exceptions, hour violations, things like that. Interfering with an enforcement officer's duties is a violation. Allowing a minor to violate the act or having a minor violate the act is a violation. Failure to provide records to our department and falsification of records. We can prosecute violations in two venues. The first one is the department holds administrative hearings. Those are not the court system, that's within the agency. And we can issue fines up to $5,000 per violation, order corrective action. The hearings are before a neutral hearing examiner, and parties have a right of appeal to Commonwealth Court. We can also file criminal actions. That's typically before district justice. And that's a $500 fine per violation for the first conviction, and a $1,500 fine or 10 days imprisonment for subsequent convictions. And again, we have 5 regional offices who are glad to assist you or employees. And our website has the law, the regulations, complaint form. We have a list of prohibited occupations, the mandatory poster. Pennsylvania Department of Education also has a website that addresses child labor issues. So, Brian, do you have anything to add before we open it for questions?
The only quick thing to add in for the child labor aspect is those who follow our Department of Labor and Industry press releases may notice that we have seen a very remarkable increase in child labor complaints and investigations this year compared to last year. So this is also, I believe, happening in other states, also on a federal level. We are working our best with employers and different folks out there to make them come into compliance, but there are times when administrative penalties need to be issued. So just wanted to make sure everyone's aware this is a very important issue for our department.
So we're available for questions on Child Labor Act, or if you have any minimum wage or wage payment collection law questions, we'll be glad to entertain those.
Thank you, Brian, James. I'm seeing some questions pop up in the chat here. We've got one from Gabrielle. How many hours can a 14 to 15-year-old work total in a full week, Monday through Sunday, when school's in session?
I'll give that, Brian, can you?
I'm bringing up the poster. We actually, while I delay my time while I'm looking for this, I do want to let everyone know we do have a child labor poster, which does have all of that information in one place. So let me bring that up. I can say on Saturdays and Sundays up to 8 hours per day each day. And before I give the wrong information about the Monday through Friday category, let me bring that up there in just 1 second. It's a great question. And one thing that I wanted while I'm looking for this, for that age group in specific,
What was it, 14 and 15
14, 15, yeah.
during the school week?
During the school week, yeah. What's the Monday through Friday, Jim, if you have that up right now?
During a regular school week, it's 18 hours.
That's right. And they cannot work past 7 p.m. at night.
Correct.
As well, that age group.
And the question was Monday through Sunday, but Brian, James, is that just Monday through Friday? And then
That's
addition,
Monday through Friday.
Right.
so 18 hours Monday through Friday, plus 8 on Saturday, plus 8 on Sunday.
Correct.
Thank you.
And by the way, remember too, for a Monday through Sunday category, all minors under the age of 18 must have at least 1 day off. They cannot work more than 6 consecutive days. So there has to be a day off in that week somewhere.
Thank you, Brian and Jim. Jean here asked if you could please clarify what the employer needs to provide to the school and parents of a minor employed, a letter confirming employment, and again at the end of employment.
Within 5 days. Yes. I call it the 5-day rule on joining, the 5-day rule on quitting or layoff. Within 5 days, you must send to the school district, basically the individual that provided the work permit. And we also have that information now on our Child Labor Act poster, a letter. And I want to get this.
Yeah, and Jim, I have that readily available. I can read that if you don't have that.
Go ahead.
The employer must submit written notification of the minor's normal duties and the employment hours, the minor's age, and the work permit number back to the issuing officer. And that's at the time of hiring, 5 days. Within that, also the time of termination within 5 days.
And we also put that requirement on the Child Labor Act poster, which is on our website.
Correct.
Like, I guess our newest version of the Child Labor Act poster.
Yep.
Susan
And
had
now we changed our poster too. This is important for your members to know. Now that we've changed our poster, undoubtedly a lot of poster companies out there will try to resell some of that to you guys. Remember, they're all for free on our website, so you can download the newest poster at any time.
Thanks, Brian. That's a good heads up, and we could share that as well. Another question here from Susan: can we allow a salaried employee to work a second job as a tip server?
Interesting question, Jim. I'll let you field this if you have that knowledge. I would say this might be better handled by the U.S. Department of Labor because of the regulatory authority of a tipped or of a salaried. We have to assume we're talking a salaried manager, possibly, right? But we don't know that in the scenario of a salary manager versus salaried non-manager is probably important. So, Jim, any thoughts on that question?
Well, there is that. I think at least there's a certain amount of time that they have to be worked. If they're working non-tip related jobs for a certain amount of time, I think that would disqualify them from that. I think if they're working, was it over 80%?
Well, I believe there's a certain managerial limit under federal law that they must be an actual manager. And perhaps this question is better handled by us talking to whomever that member was. Jim's contact info or my contact info is out there. This is actually probably very specific. We would probably never say that someone cannot work a job, but an employer needs to be cautious about how payments made to ensure that they're not out of compliance. So
Zach, I can provide you an email later on to specifically address that question, if that would be helpful.
That's great. Yes, thank you, Jim. Thank you, Brian. And I'll throw my email in the chat here as well. And just to all our members and all the operators and owners on the call here, Brian and Jim, their team have always been great, always communicative with PRLA, and they've always been willing to help answer questions. So you guys could email me any questions you have afterwards. If they're not addressed today, I could always liaise between the department and we could get to the bottom of some of this stuff. Another question here, Jim and Brian, are there restrictions for what a 14, 15-year-old can do in a kitchen, specifically regarding knife usage? We know that they can't use a slicer, but can they use a knife to help with prep work?
So I will first start by saying I believe the answer is going to be yes. Power driven, no. Anything power driven, any electric knives, any electric choppers, no. I would caution this. If there's something which is not in our prohibited activity documentation, you may also want to check with the U.S. Department of Labor to see if they have it. The most stringent applies. So if there's something that we specifically say that's very stringent and they don't, ours would apply. And vice versa. If we don't say something and they have it, it would apply. We have while Jim's looking up that specific point, we have also seen an increase in not just cases reported to us, but also injuries of minors in various occupations throughout the Commonwealth, restaurants included. Some of these injuries are using non-power driven sharp edged knives. So it might be a very consequential decision that an employer needs to make. Even if there's not a specific prohibited activity, probably a decision needs to be made. How much will I have this younger person do in a kitchen that I'm okay with, right? I'm just going to put that out there for just some common sense. But Jim, it's my thought that a knife is not banned, but did you find anything?
I'd have to double check with the feds, but anything power driven and meat slicers and things like that are definitely banned. From my quick review, I don't think a regular knife is prohibited, but I will double check that for you and get back to you on that. And that was for 14, 15-year-olds.
Correct. And as I'm reviewing our document and I'm not seeing anything, but again, back to the idea of what the comfort level is there for someone, right? Just be cautious because we've seen an increase in a lot of workers' compensation related injury cases being referred to us.
And Brian, Jim, while we're on that question, any other kind of do's and don'ts that you'd want to flag as it relates to minors working in doing kitchen work? These are, this is a common question we get oftentimes. The knife thing has come up a few times, but otherwise, I could, any additional information you guys share, I could always get that out to our members in the near future.
Yeah, so clearly there's some things broken down by different age groups. I would say one of the most common violations that happen for a 14, 15-year-old is someone working in an establishment that has a Sunday sales license, right? That's obviously a do not go there category, right? You want to make sure that there's no 14, 15-year-olds in an environment like that, unless it's explicit, possibly the ski resort, the bowling alley. We're talking restaurants, be careful. Also, baking machinery. Baking machinery actually has some very specific prohibitions in our prohibited occupations listing. What I think might be beneficial, Zach, is for us to send you, and if I can do this during this meeting, I will. I'll drop in the chat. Otherwise, I'll send this link to you now. We have a listing on our website of prohibited occupation by age group broken down that I think will be very beneficial for your members, and I'll send that to you.
Thank you, Brian. Appreciate that. We can certainly get that out to our membership. Next question here, back to tip pooling from Lynn. Can hosts participate in a tip pool at a restaurant?
So Jim, I'll take the first stab at this one. And I would say, first of all, it's probably important for us to know some more details. Clearly, it might be a very specific question that we have to talk to someone about, but remember the two important things. Customarily, someone who receives tips, number one, what is that type of person? Number two, if you're going to have people who do not customarily receive tips in a tip pool, what does everyone make an hour, right? Because if you remember from our tipped regulation stuff last year that we've done, tip pools that include people who are paid at least the minimum wage or above can include both tipped and non-tipped employees, right? So if you pull in the kitchen staff with everyone and everyone's making 15 bucks an hour, there's not going to be a violation there. It's going to be the violation if the front of the house is making less than the 725 and they're pooling with people who make far more. Concerning the host and the duties of that specific host or hostess, my thought would be we should talk to whomever that member is specifically, but we have to really think about in the industry, is that someone who normally receives tips for the work that they do, right? I would have that member, whoever that was that asked that, we should probably talk to them specific, and Jim could reach back out.
I'll follow up with that with an email to you, Zach.
Thank you, Jim. Thank you, Brian. And yeah, I think you guys point out something well, which very well important, is that you know, are they regularly and customarily receiving tips? And then, you know, what does that look like in any tip pool compared to the other employees that you would like to put in that tip pool? Can certainly follow up with you guys on that. Next question here: can a 14 and 15-year-old work in a restaurant where alcohol is served?
I was on mute. No, they cannot. So remember, now we have some, and as Jim mentioned, there's some of the outliers, the bowling alley, the ski resort, or perhaps if it's an entertainment industry thing, you might have a place completely separate from where the entertainment's happening. But in a Sunday sales environment, a restaurant that has a Sunday sales license to serve alcohol, they should not be employing 14, 15-year-olds. 16, 17 can work there as long as they don't touch, don't serve, don't clean glasses that have it. And there's some ramifications, not just with child labor, but also the liquor control license that they have.
Thank you, Brian. Also on the 14, 15-year-old category of questions here, can a 14 or 15-year-old use a fryer or a flat top? And also, as a follow-up to that, how about a 16, 17-year-old? Do you need to be 18 to use these items, and also things like a slicer?
Slicer, yes, 18 for sure. No one at all under the age of 18 should be using a slicer. And I will actually, on the other stuff too, we'll answer that as well. But I believe there's some federal limitations when it comes to a deep fryer for the 14 and 15-year-old age group. While I look that up, I want to just, this is a great opportunity to put out a word of caution. Okay. So I've been seeing a certain large chain restaurant recently advertise that they're doing fresh served meat in their facilities with a meat slicer. And we also know that that certain facility, that certain chain restaurant employs a lot of kids under the age of 18. Please be cautious. And if you can spread the word, people under the age of 18 should not be using a meat slicer. And that's when I saw that advertising, it got me a bit concerned because of that. Concerning 14, 15, Jim, do you know off the top of your head, I believe federal law prohibits 14, 15 from a deep fryer, but I could very well be wrong. Do you have that information?
I don't have it. I believe so, but I'll double check that and I'll
Yeah.
add it to that email. But I think so, but I better double check that for you.
Yeah. Since we're quoting federal law, we have to make sure.
Thank you. And we could be sure to send some follow-up. If you don't subscribe to the PRLA daily update, we'll send some follow-up there, and then also to this to this list of you know, the group of members that have registered for this webinar. Next question here, James and Brian.
Zach, do you mind doing one more thing? On our document, which I just sent you in your email, it is a prohibited activity for minors under 16 for cooking, except with gas and electric grills that do not involve cooking over an open flame, and with deep fryers that automatically lower and raise baskets. So we have something specific in our rule, but we have to be very cautious because if the federal government allows it even less than we do, we want to make sure that we're aware of that and provide the best information.
Thank you, Brian, and I'll be sure to check that out. The next question here from Leah: when you send a notice of employment to a minor's school upon hire and termination, is there a certain way that should be sent? Can it be sent via email, mail? Is it up to them to choose? And how do you record that the school has received that notice?
It just has to be in writing. So long as it's in writing, I recommend that the employer keep a copy because they're supposed to show it. Email has proof of sending. They have that receipt feature. Mailing, you can do proof of mailing. You can do certified mail. proof of mailing would probably be better than certified mail because people are working from home and
Sure.
things like that. But just, I mean, the requirement is keeping a copy and just sending it in writing.
Thank you, Jim. Can minors, and this is the last question. If you do have any additional questions, please feel free to add them to the chat. Otherwise, I know we just rounded the hour here. Last question that I have in the chat: can minors clean fryers if warm oil is covered with a lid?
Let's research that one. I want to be cautious on that. So just so we know the scenario for whomever that is, it sounds like the deep fryer is turned off. It's cooling down. A lid covers the oil. And then the cleaning process would involve what? Draining the oil? Like what specifically are they doing? Are they actually draining out that oil, or are they just cleaning the surface somehow? And perhaps we'll have to talk to whomever this is too about that.
Sure, Brian, and I don't know the answer to that question. Carl, don't know if you want to jump in. Otherwise, maybe we could connect offline and you know, we could always reach out to the department for some additional follow-up.
These are all great questions, but and actually I'm really happy that we're hearing these questions. It's good that people are making sure that they're doing the right stuff, and we're grateful to hear this.
Well, Brian, Jim, that kind of rounds out the questions I have in the chat. As always, we of course appreciate you being here. We thank you for all of your efforts to communicate with not only the industry but with PRLA and the association along the way. To close things out, I want to introduce PRLA President and CEO Joe Massaro.
Well, thank you very much, Zach and Lauren, for helping to organize today's webinar. And thank you especially to Brian and Jim for participating and helping ensure that all of our members comply and can run their businesses effectively and in compliance. So thank you all. Also, thanks to our participants, and I wish you all a great day.
Thank you. And Zach, I'll get you, I think there's 5 questions. We promise a follow-up, and I have your email and I'll send you responses. And if anyone thinks of additional questions on either topic, I guess, Zach, let me know. We'll be glad to answer them.
Will do, Jim. Brian, thank you both for your time. I'm going to stick around here. I just threw my email in the chat. I'm going to give everybody some time to kind of jot that down. Feel free to reach out to PRLA if we could help address any of your questions or concerns. And thank you, everyone, for joining us.
Thank you for your time. Have a good one, everyone.